Now this is the case of Lee versus Lee. It is the case similar to the Salomon versus Salomon company, where the Salomon companies, it was decided that the company is itself a legal entity and there is no means of the shareholders, and shareholders cannot be treated as an owner of the company. But now, in case of Lee versus Lee Air Farming Limited, it was in judgment of 1961, All England Reporter. What was the fact of this case? In case of Lee versus Lee was established a company for the air traveling, where in case of air traveling, the Lee himself appointed as a pilot in the company. He was the promoter of the company, Lee Air Farming Limited. He was himself promoted the company, himself established the company, now himself appointed as a pilot of the company. Unfortunately, there was a crash of the pilot in the company. There was a crash of aircraft where the Lee was died. Wife of the Lee want to claim the compensation from the company. The remaining shareholders and the other creditors of the company is claiming that Mr. Lee was the owner of the company, Lee was established the company, he was the first promoter of the company, he himself appointed as a pilot. He cannot claim Lee's company because she himself is a owner as a succession of the shares of Mr. Lee. The Salomon versus Salomon decision was repeated here. An honorable court was decided that no, Mrs. Lee can claim the compensation as an accidental compensation from the company because company is the separate legal entity. Because company is the separate legal entity and Mr. Lee was the employee in the company. Even it may be possible that he was the promoter of the company, it is possible that he is the director of the company, it is possible that he was invested in the company. It is also possible that he is the managing director, after all he is the manager of the company. But when the company was established, it can't be said that the director of the company or managing director of the company or the shareholders of the company is the owner of the company. No, they are not the owner of the company, they are the shareholder only. And if they are the shareholder, now someone want to say that if they are the shareholder, then how the wife of Mr. Lee can claim over the Lee and company? Honorable court said no, company is a separate legal entity. So Lee's Air Farming Limited is a company, so she can claim the accidental compensation from the company and all the members or from the assets of the company, the compensation must be paid. Because shareholder is not the owner of the company. So this case, Lee versus Lee Air Farming Company, is similar to the Salomon versus Salomon and Company. But see, sometimes it is possible that some directors was doing something wrong with the company, and by doing such wrong, they want to cheat the another creditors. In these cases, the corporate will of the company may be lifted, and the original person who does the wrong with the company or on behalf of the company may be searched out and criminal case may be filed against him. The criminal case may be filed against him does not mean that he was the owner or that he has to pay the compensation or he has to do something. No, company is a separate legal entity. That's why the company will decide that what must be done or what must be happen with the another members, with the outsiders. Right now here, despite of the ownership, despite of the shareholding by the Mr. Lee, despite of the forming of the company by Mr. Lee, despite of the promotion of the company by Mr. Lee, he was the pilot in fact, and he was appointed the pilot in the company. So, as a widow of the pilot, the wife of Mr. Lee can claim from the Lee Air Forming Limited. So, this concept is saying that company itself is a legal entity and separate legal entity. There is no connection of the company with the shareholders. Shareholders are entitled to get the to get the dividend only. They can't take, they can't be said that they are the owner and they will acquire, they will get the assets of the company as an owner. No, they are not the owners. They are they having a right to get the dividend only. And right to get the dividend means whatever the profit is gained by the company and board of directors decided that we have to pay such and such amount to the shareholders in this percentage, they may announce. So as another persons who may be the share company, Lee is also the shareholder of the company. So what is the mean that he was the first incorporator? What is the mean that he was the first promoter? What is the mean that he was a shareholder? What is the mean that after all management was in his hand? It is possible that the management is in his hand, but director is itself a employee. Director is gained the position due to acquisition of the shares, or it may be possible that he got it the job as a director in the company. So there may be some compensatory or there may be some sweet shares to the director, but he is the director does not mean he is the owner. He was not the owner in the company. Ownership belongs to the company only, and he was the shareholder in the company. He was the managing director of the company. He was the pilot of the company. Due to pilot, the wife of Mr. Lee can claim the compensation from the company. Otherwise, we have to lift the corporate will and find out who was the wrongdoer. Wrongdoer does not mean, if Mr. Lee was himself a wrongdoer in forming the company, does not mean that his wife cannot claim the compensation, accidental compensation from the company. Anything?